Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends again. Hello again. Hello again. Thank you so much for coming and hang out with me. Many of you for the second time today. The last stream ran a lot longer than I thought it would. Yeah, it was almost 7 hours. We did it though. We did it. We covered very close to all of the Afroman trial in 2 parts. Today was the second part, including the verdict. Oh, look, there's still the lemon pound cake in the corner. And what a great palate cleanser trial that was. I was disappointed I couldn't cover it yesterday, but it's spring break. My kids come first. We already had something planned. So I was shocked that there was already a verdict in that case. And sorry to spoil it for you. I forgot to take the banner down. But if you haven't had a chance to watch it, go back and watch it, especially Afroman's testimony, because he is the face of the First Amendment for 2026 that I guess we didn't really know that we needed. And because these 7 cops sued him for making merch, essentially, with his likenesses on them after an improper raid at his house and not wanting to pay for the damages, he made some videos, he made some merch, and they didn't like it. So they sued him. And we just watched the conclusion of that trial today. It was only 3 days long, the trial. So it was something. It was something. And it was, I don't want to spoil it for you, even though the banner might have just done that, but it was fun. It was fun and it was good to see. And it was something I think we all needed. That happens sometimes, right? You lost the sound. I don't know. The chat just froze too. So I don't know what had happened. Yeah, if you try and write Afroman in the chat, it will definitely change. The spelling will change. It will auto correct to something else. And then everyone's like changing them, correcting their chat. It's been a long day already. It's been a long day. Okay. What should we do? Because I was with my kids yesterday, I could not cover the Kelsey Fitzsimmons hearing live. That was like the first one I think that I haven't covered live since I started covering the case. So I just Court Chopped has a video up. Do you want to look at the hearing again? Do you want to review the hearing together? Boston 10's audio was not great, but when it gets to the colloquy, we can flip over to Court Chopped. All right. If you did not watch my coverage this morning on Afroman, where were you? Number one, and you did not get to hear the quotes of the day, which I don't know where I put them, but wait, here they are. The quotes of the day. Motivational quotes. You want to do the hearing? And then I've also got the original text messages between Kelsey and Justin, and I will read those for you. And then we will talk about what had happened yesterday. They charged a Boston cop with manslaughter for shooting a carjacker. Okay, I didn't see that yet. Can't stop to cover it, but I'll check it out later. Thank you very much. This quote is from yesterday, March 18th. Mahatma Gandhi said, "I suppose leadership at one time meant muscles, but today it means getting along with people." That was number one. I do not have the audio of Justin's calls. And you know what? Baker did that show. I watched it on Baker's show. And I don't know. People were going in there like, can you give him to me? Can you give him to me? Can you give him to me? While he's alive, like covering it himself. Could anybody let the man cover something by himself without trying to get it for other people so that they can go watch other people cover it? Stop doing that. Please stop doing that. Don't do it on my behalf anyway. This is today's quote, Thursday, March 19th, 2026. Quote, "If you do not conquer self, you will be conquered by self." Oh, self-sabotage. You can be your own worst enemy. That's Napoleon Hill. Remember, I've been saying I can't wait to hear the audio of those calls because the tone is probably so much different than we think it will be. It was a win for America. That's what he said. That's what he said. Afroman. All right. I'm going to pull an empowerment card for today because we have not done that yet. All right. Do we need to review the YouTube courtesy rules like I've been doing like every day? And I will not be rage baited by that person out there who's trying to rage bait me. If you know, you know. Thanks everyone who sent it to me today. I haven't even had a chance to look at it yet. But let's just say this. If you think that Chris Watts's wife deserved to be murdered by him, I think that says a lot about your character. Here we go. May your coffee be hot and your eyeliner be even. That's your empowerment card of the day. May your coffee be hot and your eyeliner be even. I mean, sometimes we need makeup tips too. Right? Sometimes we do. Some people more than others. All right. Let us go first to I guess we'll use Boston 10. But when I was listening to it in the car, it was not such great audio, but we have the ability to boost it. We can boost it. All right. This is yesterday's final pretrial hearing. All right, here we go. Well, it would be helpful if I put it on the screen. Here we go. And we have an opening shot of a close-up of Courtney's hair. Courtney is Tim Bradl, paralegal. And here's Boston 10. Judge Karp, hearing from yesterday.
Good morning, Your Honor.
Courtney's ready for a close-up.
March 18th, 2026, Courtroom 4, Lawrence, Superior Court. The Honorable Justice Jeff Karp presiding. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311, scheduled today for a trial readiness conference. Could counsel please identify themselves for the record?
Good morning, Your Honor. James Cooper, Associate on behalf of the Commonwealth.
Good morning.
Good morning, Your Honor. Marina Moriarty.
Good morning, Your Honor. Tim Bradl on behalf of Kelsey Fitzsimmons.
Good morning, Your Honor. Martha Coakley on behalf of Kelsey Fitzsimmons.
Good morning. Good morning, Ms. Fitzsimmons. You folks can have a seat.
And if I may, Judge, I have Ms. Healy with me, or she stays at counsel.
Yeah, I'm sorry, her name again?
Ms. Healy, Courtney Healy, our paralegal.
Okay. Yeah, that's fine.
Thank you so much.
Okay, so we're on to, really on to discuss the juror questionnaire, the draft of the juror questionnaire that I emailed you folks on Friday. I did have some preliminary questions. If you don't mind, I think these are fairly quick. So let me just ask about trial readiness. Are both sides ready to begin impanelment on Monday and then start the trial the morning after we get our 14th juror?
Yes.
Okay.
Judge, on that point, you know, I don't want to waste a lot of the court's time. So just to say,
The audio is seemingly going in and out. But as soon as we get to the colloquy, I'm going to move over to Court Chops feed. Judge says he wants to go over the jury questionnaires, and Tim Bradl says, I don't want to waste a lot of time on that. So here's what I have to say.
suggestion is could we do the rest of the housekeeping matters, take a quick break, and then put the questionnaire to the end? Because we may not do it. It may be a moot point.
Okay, I actually, that's one, you're ahead of me on my agenda, because I was going to, let me just skip to that item, right, what you're speaking about. So what I was going to say, mention to you is that I believe at the last hearing you mentioned, Mr. Bradl, the possibility of Ms. Fitzsimmons waiving her right to a jury trial.
Yes.
And what I was going to say to you, and we'll give you some time, we'll take a break and give you some time to talk about it, but what I was going to mention to you is that I really want to, it appears to me that the law, both the statute and the rule, give me some discretion as to whether I would grant the waiver. And the only reason I would, well, let me just tell you my thinking is I would like to do everything possible to avoid having to bring 70-ish jurors in on Monday if it's going to be a waiver. So what I was going to say to you is I would need a decision by Friday, but it sounds as though maybe you'll want to talk with your client about that even today. So
Exactly.
we'll pause.
We were going to have to take for like 5 minutes and then.
We'll when we get to that point, you'll take as much time as you need. All right, a couple other quick things. So the trial, we're trying to coordinate having the trial be held in courtroom 2 on the 2nd floor, just to accommodate more audience and media members than we.
Wow. An accommodating judge for the media and people who want to see the trial. And he knows that there's a lot of public interest in this case. So did Judge Drexler, and he wasn't happy about it because originally this was in Salem, as you may recall, and Judge Drexler was on this case one day when Judge McCarthy Neyman was, I don't know, out. And apparently we overloaded the phone lines because they don't have Zoom in Salem. They only have like a party line that you have to call and just listen to the audio. And Judge Drexler was really mad that, first of all, Bradl didn't show up, even though the court clerk told him it was a remote conference. Thank you, Gen X, for gifting the memberships. They told him it was going to be a remote hearing, and also because we overloaded their technology. We overloaded some symptoms, their system. Okay. And so there's that. But this judge wants to accommodate the media and the audience. And so he wants to move it to a bigger courtroom.
Can fit in this courtroom because, as an example, the camera that is set up is actually, I think, either in the jury box or just too close for comfort. So our hope is that the trial will occur, whether it's bench or jury, down in the courtroom number 2. We are still working on some logistics at our end, and you folks, especially the Commonwealth, may have some logistics that you'll need to go over with Mr. Wayne. If the logistics cannot be overcome, then they can't be overcome. But at least that would be my preference, is to have a bigger courtroom and a larger courtroom is here. All right, so that's that. And also, I will need, if there's going to be a juror questionnaire, I'm still missing Dr. Zeisel's address, which used to be in Brookline. I'm assuming, is he still in Brookline?
That's another development, Judge. We're actually not going to call Dr. Zeisel.
Dr. Zeisel is not going to be testifying. That is also new news. Sound is most excellent. You can hear it better. Thank you. Somebody else said I can't hear a thing. Okay. Interesting. No Dr. Zeisel, not coming in at all. He came to her last hearing to support her in the audience, and he was ready in case the judge needed him to testify with regard to her being able to see her baby or things like that. And so, interesting. No Dr. Zeisel. We loved him. We loved his testimony during Lucy Medina's trial.
Okay, all right, but, so would his, well, we'll get to it later. I'll also need, when and if we get to it, I need an address for Charles DeChara. Is that Commonwealth's witness or the?
No, it's the defense put him on there, but I'm working on that actually, because,
You're working on the address?
yeah,
But the defense, it's a defense witness?
it was an independent investigation that was done by the North Andover police, and they created a report.
Oh.
I wasn't gonna call him, he put him on the witness list, but I think I probably have better.
Well, apparently the North Andover Police Department did an independent investigation. And that person who did the independent investigation is on the defense list. I feel like I have this sped up, but I don't think I do. It's on normal speed. Of course I'll be covering it, even though it's a bench trial. We've covered lots of bench trials, including Penny McGee in front of Judge Cannoni and others. Recently, Ruth Miller in Ohio. Okay. I don't know if it's the courtroom from Lucy Medina's trial. That I don't know. Earbuds do help. I love Kelsey's earrings too. All right. Kelsey looks beautiful. Yeah. Independent investigation in air quotes. Gubatosi is the king of the air quotes. Let's see how many times he does it today. Zeisel is going to be great in family court, but he was supposed to testify in this trial as well. Just being clear. Okay.
Quote unquote connections to get
Okay.
an address. So.
Yeah, just the town or the name of the business,
Understood.
something sooner than later. All right, so those were the only two items that I missed. And by the way, I did take out Ms. Fitzsimmons as being listed as a witness. So you're going to actually see on the next version that in order to save me having to renumber, I just put number 20 intentionally omitted. There's no reason to, and I know why you did it, both sides did it, but there's no reason to put Ms. Fitzsimmons. There's going to be plenty of questions about knowledge about Ms. Fitzsimmons in the case that her name won't be necessary on there. A couple other questions. One is on the SCRAM device. Is that is probation?
Yes.
Oh,
Yes.
hi, how are you?
Good.
Do you mind just stating your name for the record?
Yes, Your Honor, Probation Officer Tony Kidder.
Okay, and Officer Kidder,
Probation officer is in the room, and this was a great question from the judge.
well, everyone, let me just think out loud for a moment. I'm concerned, or should I be concerned, that Ms. Fitzsimmons is going to be alerted during the trial to blow into a SCRAM device? Yes.
Yes, Your Honor, I did speak to my supervisor in regards to the SCRAM earlier this morning, and I was going to contact electronic monitoring to make sure that it did not go off during the time that she was in the courthouse.
Okay. All right,
And they're going to make sure the SCRAM monitor random testing bell, or however they alert her, does not go off during the trial, because how prejudicial would that be in front of a jury? There needs to be stopping the trial for her to blow into the thing. They're not even supposed to know when a defendant is in custody. Remember, that's why they let, Corey Richens and every other defendant wear street clothes instead of prison garb when they come in for their trial. Then the jury's not even supposed to know they're in custody. Imagine like them being able to see her ankle monitor and then it goes off and she's got to blow into the thing. I'm glad this judge is cognizant of it.
I don't know what I don't know. And all I know about the SCRAM device is what the probation officer at the last hearing told me about. So I just want to make sure, I'm sure that you.
It's a bench trial, yes. We know that now. Some people haven't watched it, so they didn't know. But it has not yet been decided at this point in the hearing. And so that is why the judge is addressing it now. because the defendant has not yet said in court that she wants a bench trial. She's not been given the colloquy. And even if she wants a bench trial, the judge doesn't have to allow it. So again, if you watched the hearing already yesterday, you may know how it ends up. I am going over the hearing from yesterday today because I couldn't do it yesterday. And by this point in the hearing, it has not been decided yet. Don't be confused. Just stick with me.
Folks are out in front of this, but let's just make sure that it's not visible to jurors or, and that she isn't seen lugging it around or throwing into it in the courthouse. It's still a small courthouse, right? So if probation can do something to shut it off during the court proceedings, that would be great. Actually, better yet, during the time when Ms. Fitzsimmons will be near in this building, and again, near even coming through parking, I just don't want to take a chance that a juror is going to, potential juror is going to see her blowing into the screen.
Yes, Your Honor, I will make sure.
All right. All right, and then last thing is, so I'm already thinking about jury instructions, whether it's jury instructions or whether it's instructions to myself. And so there's two theories of assault, right? Or two ways of assault can be committed. An attempted battery, threatened battery. Is this one, the other, or both? Or what is this? Both. Just that's all I wanted to know whether I needed to. Okay. So really, I don't have anything else. There is, Commonwealth filed a motion. So is that something that you want to do before we break? Does that make sense?
Yeah, the Commonwealth filed a motion in limine on Friday, I believe, or the weekend, I'm sorry. The Commonwealth filed a motion in limine seeking to admit a number of text messages between the defendant and her ex-fiancé, Mr. Aylaian. There's text messages.
We went over the motion. The Commonwealth wants all of the text messages between Justin and Kelsey from the day of the shooting, which was June 30th, 2025, to be admitted into evidence. I have the text messages. We're going to look at them after this.
That we would seek to introduce span the day of the shooting, so just the day of.
I'm sorry, just let me interrupt, all right? So just setting it up for the record. So you're referring to paper 82, which is the Commonwealth's motion to eliminate to admit the defendant's text messages from the day of the assault. I did have some trouble reading them, but then I was given a better copy. But let me just...
Well, the day of the assault, first of all, the assault against Noonan, for which she is on trial, is an alleged assault, Your Honor. Unless you're referring to the shooting of Kelsey by Noonan, which is actually an assault. But I digress.
Ask just yes or no, Mr. Bradl. Is there an objection to the motion?
There is, Your Honor.
Okay, all right, so now I'll hear you. Thank you.
So the Commonwealth suggests that the one thing that I think everyone can agree upon in this case is that the defendant's state of mind on June 30th, 2025 is the most relevant issue before the jury. And what more insight into the defendant's state of mind on the question can we get than her text messages with Mr. Aylaian? I would suggest the Commonwealth is not seeking to admit over the weekend, over a period of time, but literally it is from the morning of June 30th through the afternoon, approximately sometime after 2 o'clock on June 30th. I would suggest that generally they're not particularly prejudicial, but they are relevant because they show that she is angry, upset, at times despondent, and clearly having a conflict with Mr. Aylaian, and this is prior to the service of the restraining order by the North Andover police.
So your theory is they show what? Anger? What else?
They show her state of mind. And
No, I know that, but you gave me a laundry list of what the state of mind you say can be gleaned from these.
from a Commonwealth perspective, she's angry at Mr. Aylaian for not. Mr. Aylaian has clearly is not at the house, has separated from her for a period of time, and she is angry and is trying to get him to.
You can't have it both ways. You can't say he's separated from her And then he's got the right to come into the house, and that's why you're not prosecuting him. But we're going to take a look at the messages after this. And that's great if other creators have already gone over the messages, but you don't need to mention it in the chat so that people can go. It's drawing people. I'm tired of explaining it. I'm just going to start deleting comments. Okay, that's it. Goodbye.
Come back to the house and trying to reconcile. So I would suggest that that is consistent with the Commonwealth theory that this shooting happened when the defendant heard Mr. Aylaian.
Kelsey's opinions on Justin. All right, I'm going to hear what the judge has to say. Hold on.
Shooting happened.
The defendant raising her gun towards Patrick Noonan, and Patrick Noonan, in response, shooting the defendant happened at the time when Mr. Aylaian was in the house.
Okay, so I'm sorry, are you saying that it's the Commonwealth's theory that Ms. Fitzsimmons heard Mr. Aylaian in the house and then reacted to it, or?
That's one of the Commonwealth theories, yes.
That's one of the Commonwealth theories. Why did you even have Justin in the house? Justin has a restraining order against Kelsey, right? We know this, right? Justin went out that day and got a restraining order on her. And we know this because that's the flipping reason her coworkers are there, is to serve her with a restraining order. And yet they're also inviting Justin to the house to take the baby away. Come on. What? What? Why is he in the house in the first place? He never should have been allowed in that house. He never should have been brought over there to take the baby. And when we listened to some of the audio, because some of you guys sent it to me of the calls that we went over, we had transcripts, we didn't have the audio. They're on notice that when she gets served with the order, she may flip out, right? He never should have been there. This is what you call a cover your ass kind of trial, okay? North Andover PD is covering their ass. They have so much liability here, potentially, in my opinion, that they have to go through with this, even though Kelsey was the one who was shot by one of their own, and that's exactly why. Because of the bad advice that Justin was given over the phone by one of their own, by the way that they were protecting Justin over one of their own, by the way that they may have conspired with Justin to get these orders instead of protecting one of their own. It's wild. That's why they're digging their feet in on this. They have to do it. Justin never should have been anywhere near that house.
And I think the testimony would be something to the effect of the defendant said, keep him away from me.
Like in this exchange in the bedroom or near the bedroom or whatever?
Yes.
All right. I'm sorry, anything else?
No, I would suggest that it's certainly more probative than prejudicial. If you just look at the text, there's nothing particularly outrageous in the text, but it does go to show our state of mind.
So,
State of mind.
And how would these?
So they want these text messages in to show Kelsey's state of mind. Unless Kelsey is saying in these text messages, I want to kill Noonan, I'm not really sure how they're relevant. And when we read them, and I actually didn't read them all, I just sort of skimmed them. Thank you, Billy. He says, I love how you get as angry as I do when watching such and such. I do. I take it very personally. I do. I have a bias. To, due process and the First Amendment. If you want to watch a neutral lawyer, you can do that. There are neutral law tubers out there. I'm not one of them. I'm going to tell you my opinions, and I'm not shy about it. The only thing that happens from me sitting on a fence is that I get splinters. Okay? That's it. I don't like splinters. Do you? Thank you. It's passion.
They'd be admitted in this format?
Yes.
Like just, and how did the Commonwealth obtain these?
The Commonwealth prepped Mr. Aylaian on Friday, and he provided them to the Commonwealth.
Oh, kind of like Higgins brought in copies of his text messages. The Commonwealth prepped Aylaian on Friday. That's the first time they've ever spoken to him. They've even said they're not going to charge him with the breaking and entering and all of the things that he did by stealing Kelsey's passport and money and laptop and logging into her accounts. And they don't think there's anything wrong with that, because they really can't, because their own officer said it was okay for him to go in the house because, he had a right to be there. We know you live there, Justin. We know you live there. We're going to hear the audio. Justin gave them to you. Did he delete any of them? Is there metadata? He just printed up screenshots of his text messages with Kelsey, and you're just going to be like, okay, trust me, bro. Yeah, sure. Did anybody extract them from Justin's phone? Do we have any chain of custody? How do we know that these are the full messages? He just brought them in. Did he take a page out of Higgins' book? Did Higgins call him up and try and help him out and then teach him where to go to the military base to destroy and crack his SIM card and put it into a different dump? What kind of world are we living in? What kind of world are we living in? Upside down, inside out Narnia of Massachusetts. And what is even appropriate? Do we put Chaka in the corner at this point because we're in the land of the lost? Do we put the Guzma in the corner for the Guzma coma scale? Or the Guzma coma score? Do we put some lemon pound cake? Or just like Afroman should just be in the corner at all times? Trust me, bro. Justin gave him to us, so we should just be able to get him in. First time they've ever spoken to him. Okay, cool.
So if we provided, if we authenticated through Mr. Aylaian, he would explain that he received them on his phone and that this is a fair and accurate depiction of the screenshots he took from his phone of the text messages he had that day with the defendant.
And is this all of the text messages that they exchanged on that day, or is this a portion of them?
No, that is from that day. That is all.
All right, and the other thing that if we can just flag it and we'll circle back, is that I provisionally impounded. So I was out on Monday when this was filed, I believe, and I provisionally impounded the motion and the exhibit being text messages because I saw that Mr. Bradl had requested it in an email or something. So I just want to, because it's provisional, I want to discuss how we do that. All right, and all right. So let me hear from Mr. Bradl.
Thank you, Judge. So evidence has to have a rational tendency to prove a proposition in the case for relevancy. And it's not a rational connection to say that because Kelsey was supposedly mad at Justin on this day, that she's going to shoot her colleague from North Andover. It's like if I'm mad at Charlie from Mass Live for reporting, and then I run into the law girls later on.
Shout out to Charlie from Mass Live and the law girls. The law girls are here. They're in the chat. They do the work. They go around. They ask questions. They tape things for us. If it wasn't for the law girls, we wouldn't have been able to watch Lucy Medina. Okay? Tim Bradl knows it. He's shouting you guys out.
I'm not going to do anything bad to the law girls because I'm mad at Charlie.
You must be the law girls. I am not on.
He said that. He said, you must be the law girls. Look at you guys getting all over the big TV.
Social media or any of that. So yeah. Don't assume I know who the folks are, but welcome. And you referred to another member of the media?
Yes. This is the law girls. They have their own blog. And it's just a rational thing. I mean, it's just, this just opens the door to the Justin stuff that is completely irrelevant to whether or not she assaulted Noonan in the bedroom when it was just the two of them. There's no relevance to it, to this charge. And there is prejudice, there is unfair prejudice to show that she's in a fight with her boyfriend. Nobody wants to be judged on that, Proposition A, when Proposition B is completely different, that we're here for trial on. So I just don't see the connection. Her state of mind about Justin is not her state of mind about Noonan. And there's just no possible rational tendency in terms of relevance that because she's mad at some totally different guy, that she's going to hurt her colleague and friend from work.
Well, here's the thing, perhaps I need to do a analysis under Rule 403, but I mean, it's relevant in the sense that the Commonwealth has to prove intent. It is a general intent, and it's also relevant because I think that Ms. Fitzsimmons has put her state of mind somewhat at issue because there's information, at least that I've heard, that she wasn't, that if she had the gun, she didn't point it at the officer, she pointed it at herself because of her mental state. So wouldn't this be evidence, again, just not for the truth, but for just to show her mental state at the time of the incident?
Judge sounds like he's sort of leaning towards Kelsey wanting to harm herself instead of Noonan. And the vibe that I'm getting is that's how he reads the text messages, to show that they might be helpful to Kelsey's defense, that she didn't point the gun at him, she pointed it at herself. When we read the text messages, you can let me know what you think.
So my strategy on that, and I'm happy to share it, is just that there's enough from the content of the restraining order that without having to open the door to mini trials about who was right between her and Justin, and what are they fighting about and what's going on, and what are the details of that. She just received a restraining order that said, you know, as I said the other day, I won't go into it again, you know, all the things that order implied were horrible, tragic, and awful. And that prompted her to have a sad, brief moment of intent to self-harm. And thankfully it didn't happen.
Let me say this. I've read these text messages, and I arguably thought that they helped you. Because
and he comes right out and says it. He comes right out and says it. Now listen, just because Kelsey says she wants a bench trial doesn't mean the judge has to agree. And apparently in Massachusetts, the Commonwealth is allowed to object. And they haven't made that election yet during up to this point in the hearing that happened yesterday. But this judge is saying straight up, I think the text messages help her. And her defense that she was pointing the gun at herself and not Noonan. So now, Mr. Air Quotes, maybe a little light bulb is going off in his head thinking, I don't want this judge deciding this case.
Sure. I know that I've read these text messages, and I arguably thought that they helped you, frankly, because sure. I know that the Commonwealth sees anger in them, and yeah, I think it could show that, but
I agree.
But they also arguably show. It's what they don't discuss, I guess. I'll just leave it at that.
And that's my point, Judge, is that it's opening doors. It's like opening more doors about this when we're not intending on opening that door. And, you know, I don't want to have that thing where, oh, well, this helps us, but then that might hurt us, and then this might help us, and then we're having a mini trial about Justin versus Kelsey.
But Mr. Bradl, with all due respect, you folks put Mr. Aylaian front and center. Maybe you changed your mind about that. It sounds like maybe in the last year and a half you have, which you have a right to do that, obviously, but he's been pretty prominent, and their relationship has been pretty prominent from the defense's perspective, from what I've heard, all right, and seen.
So if I can speak to that, I don't need to talk about it.
No, go ahead.
Sorry. So, Judge, we have to play both sides of that street because the government is pushing that. The government wanted to put, you saw that prior motion in limine where they had these 4 things that are like, you know, this is judgment day for Kelsey's entire life. You know, the government wanted to open this case up to Justin and Kelsey and what happened in Maine and all this other stuff, you know, and I think the government's backed off of that. But the government started that fight, and I have to match it. I have to be ready if, out of an abundance of caution, if the government was gonna go down that road, I gotta be ready. So that's, the Justin stuff gets, has to be vetted. And I have to be ready if he's called and if he is a witness. I have to be ready on both sides. My preference is that we have an economic trial here where, the issue is Kelsey gets this restraining order full of horrible nightmares. She acts accordingly on it. The government puts their case in, we put our case in, and the fact finder decides.
So, but don't these text messages help your client show that? Because I'm not, again, listen, the Commonwealth, you know your case, both sides. I only know what little I know from the file.
Sure.
But when I read these, yes, maybe there is anger, maybe you could say that. But there's also an absence of any concern for her mental well-being by Mr. Aylaian. Any comments made by Ms. Fitzsimmons that would lead one to believe that she was suffering emotionally at this time, which would, so I guess that's part of the analysis of when I'm doing the 403 analysis is on the prejudice to the defendant. I'm not sure that I see a lot, but I can tell you this is that there is one passage in here that I thought I saw that where he said something about her allegedly hitting him or something, and
It's on the first page, Your Honor. It's the fourth bubble on the right.
So I give you a proper on that. And so I appreciate what you're saying, Judge, about on its face, the general gist of those text messages would help in the sense of the distraught mindset. However, if that's where it sits, I can live with that in terms of but we'll talk about the hitting thing. But I'm looking at this like, I feel like the government's going to try to say that this opens more doors. And I don't want to go down this road of like going down, Justin versus Kelsey and everything in Kelsey's past going back to two other ex-boyfriends. Like, that's what I want to guard against.
Commonwealth said 2 hearings ago, this is a simple case. You said at last hearing, and it will be a simple case, but it's still simple in the sense of what happened in the bedroom.
Right.
And it seems to me that what Ms. Fitzsimmons was thinking at the time is absolutely relevant, and then her state of mind in the hours leading up to it would be relevant too. And again, let me say this. I'm making an observation about what I say that they could arguably help the defense or hurt the Commonwealth, but that's only because, again, when I'm weighing the potential prejudice to the defendant and the probative value, that's all I'm really getting at under 403. So
Judge, if I could just invite the court to just focus on that one bubble about the hitting in terms of the 403. And that's really all I'd be concerned about. So there's more to the story, of course.
All right, so let me just, in Commonwealth, what would you say if that was redacted? So that bubble and just.
I just think the first sentence of that would be fine to redact, but I do think that the second sentence is not about what you need anymore. We need to be the best parents possible, and I cannot do that in the house at this time. I think that's relevant.
So, Mr. Bradl, I don't know if you've heard that. So the Commonwealth is suggesting that. All right, so let me just back up. So my ruling is that the probative value of these, generally speaking, of the proposed exhibit outweighs any, really almost any potential prejudice to the defendant, except that the devil is in the details as to some of the content, and that one of those items being this particular passage where Mr. Aylaian is alleging that Ms. Fitzsimmons struck him in the face, even though she denies it right there in the response. So the Commonwealth is suggesting we simply just redact the first two sentences of the Pablo of Mr. Aylaian's text about that.
Should that be agreeable to the defense? Thank you.
Okay. And so that would, and the rest of that would come in starting with, it is not about what you need anymore?
Yes, sir.
Okay. And if you folks remind me at the time that I can tell the jury that it's common that things are redacted or struck from items just in case it's somehow visible that, in other words, if the jurors can glean that something's been removed, I'm happy at the request of either side to tell them why, which is basically I rule that it wasn't even missing.
And Judge, also while we're on these, I would waive the request for impoundment.
Okay, waive the request for impoundment.
Correct.
So let's talk about impoundment. What's the Commonwealth Act?
The judge is going to let the text messages in with the exception of one or two sentences from one of the paragraphs where Justin talks about Kelsey hitting him. When we get to the text messages, we'll try and figure out which sentence it is.
I'm just concerned about jurors, just knowing, but I don't know.
Your Honor, this is, I do not see a good faith reason for the Commonwealth to ask for this to be impounded, given the nature of what is in the public already.
Okay, all right, so both sides say it shouldn't be impounded, so I'm
There
gonna
we go.
vacate the, and I'll do this, Mr. Wayne, in an endorsement, but I'll vacate the provisional impoundment of that. What I'd like to do is this Commonwealth, so I have two versions, one's a vertical and one's a horizontal. Is that right? Is that the way to explain it?
Yes,
So
I think the first version was too small really to be
Yeah.
using, and so.
So can we just give this back to
Yes,
you?
please.
And then you can shred it, and this will be this landscape, right? That's landscape, okay.
And that's a good one to the.
The landscape will be the official exhibit. It will, and it can be docketed in the normal course, public, maybe, sorry, docketed to the public docket. All right. And I'll have to also endorse, I will endorse it that I'm allowing it subject to that revision, so just, all right. And, all right, so do you folks want to take a break for a few moments? Okay, all right, we'll do that. Just let Mr. Ruiz know, and you folks are.
All rise, please.
Thank you very much.
Yeah. If I want to run.
Okay, so they take a break. Hold on. Oh, please. Judge comes back.
On record in the matter of Commonwealth versus Kelsey Fitzsimmons, all counsel and the defendant are present.
Okay, Mr. Bradl?
Thank you, Your Honor. We filed two things, Judge. We filed a waiver of the right to a jury trial, and Attorney Coakley.
That's it. He said it. We filed two things. We filed a waiver of the right to a jury trial. The defendant, Kelsey Fitzsimmons, has waived her right to a jury trial, and she's entitled to do that. The Commonwealth can object, but without very good reason, the judge will typically allow it. I've been saying from the beginning, or at least from, I don't know, the past couple shows, that I think a bench trial is the way to go here for several reasons. This is a case that could be very emotional for a jury, highly emotional. We know from covering two Karen Reed trials that there are many people out there on the worldwide internet who think that Karen Reed was guilty because they didn't like her facial expressions and the way she behaved in court and the outfits that she wore. And a judge isn't going to pay attention to any of that nonsense. Right? The judge also knows a lot of stuff that's not going to come in. And I think that it's a better option for her because this is a very narrow issue, right? Did Kelsey point the gun at herself or at Noonan? And is what Noonan did in shooting her justified? But really, it's not even about what Noonan did being justified. It's basically because Noonan's not on trial here. She is. Did she point the gun at herself or Noonan? It's very narrow, very narrow. Either she assaulted Noonan with a deadly weapon or she didn't. That's it. And once you start throwing all that other mud in there and making it messy and dirty, it confuses the jury. And then they want to try and figure out, why Noonan did it. Was he justified? It just gets too messy. So she waived her right to a jury trial, but of course Gubitosi is going to object. So let's watch.
Coakley and Ms. Fitzsimmons are prepared to engage in a colloquy with you on that.
Okay.
And then the second thing you did file was a supplemental witness list that I explained to my brother a little bit. Some additional names. I would say most of it is probably abundance of caution stuff that probably they won't be called. There's one name on there that that did warrant some explanations to counsel for Commonwealth, which I gave them, and I don't expect it to really add much to the trial.
All right, so let's table that, but I do want to, if the Commonwealth wants to be heard on these additional witnesses, absolutely.
Of course.
No, I just, if I may put something on the record.
Sure.
As far as the jury waiver goes.
Well, before you do that, I was going to ask, all right, so we have a waiver. I was going to ask whether the Commonwealth takes a position, so you may.
My only position, while I have no reservations with your ability to be fair and impartial in this case. In an abundance of caution, I wanted to create a record. At some point, I don't think it was last hearing or one of the press conferences that the defense gave outside, a person asked about you, and Attorney Bradl told them and the world, I guess, that you and he worked together in the DA's office some time ago. And
Didn't I bring this up the other day? And then you guys or somebody was telling me that it was a different judge that worked with somebody else. It was like on the Karen Reed case it was a judge that was from Canton. And I was mistaken, but yeah, I guess that's what it was. It was the comments outside of the court house. One of the most recent days, the comments that Bradl made to a reporter, like, oh, he's fair. I worked with him years ago. And so of course, Gubitosi has to bring it up and object to it. Here we go.
Attorney Bradl told them and the world, I guess, that you and he worked together in the DA's office some time ago. And so I think there's a perception out there for whatever it is that the defendant had put out there. Like I said, I have no reservations as is your ability to be fair and impartial, but I think I needed to create a record about that.
No, that's a very good point. So I don't, let me say this. I said before when I was joking with our media representatives, I don't pay attention to social media. I'm not on social media purposely. I don't read or listen to or watch or whatever media accounts of what happens in cases that I preside over or that I potentially could be involved in. So I know nothing about that, but I think it does make sense for me to say a couple things related to that because it strikes me that I did discuss those things with you folks, but I did it at sidebar. All right, so I'll just state for the record that Mr. Bradl and I, all right, so we worked together, well, Mr. Bradl and I were in the same starting
class of new assistant DAs in January of '95. I have Mr. Bradl, I have a picture of all of us, including Mr. Hagan, Judge Hagan.
1995 was a very good year.
Who, like me back then, had a lot more hair. So Mr. Bradl and I were in that class, starting class together. My memory is that I was assigned ultimately after the class. I think we met for a couple of weeks. We were a training class. I was then assigned to Roxbury District Court and Mr. Bradl to Dorchester District Court. And so that was '95. I left the DA's office in 2001, and at that time I was the chief of the domestic violence unit, which was a superior court unit. So Mr. Bradl, you can correct me, I don't think that we ever worked together in the sense of worked in the same courthouse, worked on the same trial team. I'm not sure that you and I ever even had a beer together back then.
I agree, Judge. I don't recall one, and, you know, I think that I put you kind of in the same boat as Judge Deacon down in Middlesex, where, you know, we always had a respectful cordiality at work, but, you know, nothing past that. And I appeared in front of Judge Deacon, and, you know, it's never been a problem. And I left the office in '06, Your Honor, so I was there for 5 more years after you. And I haven't seen you in probably over a decade, you know, and I think the comment that Commonwealth Counsel was referring to, I recall as just sort of a generic comment that I thought your rulings were fair and that we appreciated your rulings, that I'd known you a long time, something to that effect.
Yeah, I don't think that Mr. Gubitosi was objecting. You just wanted to make sure that this trial, I've always strived that all of
Striven.
whether it's this case or other cases, that there's a level of transparency. And I think Mr. Gubitosi's point is well taken. So I think I've described on the record what the nature of our relationship was. I'm not, again, I can't say that we weren't friendly, but it seemed like I was maybe you're the crew of
different
people
judge
that you more gravitated to were from the Dorchester District Court. I was in the Roxbury District Court. But I'll also say this, is that for complete transparency, I know I had a murder trial years ago with Mr. Gubitosi. I found Archangel Morales, I don't know if you remember that.
It's all got to go on the record. But he's like, yeah, but I know you too, Gubitosi. I know you too. Carrie, thank you for pointing this out. Carrie P says that Judge Belazos, who's Aiden's judge now, is from Canton and also had a cordial relationship with Bradl. Right. That's what I'm remembering. It was a different case. Everybody's cordial with Bradl, right? There we go.
And, I found working against you was you to be a really good prosecutor and really fair, and I respected you. I continue to respect you. That's what I was referring to at sidebar. And you know, I probably spent
I was going to say, maybe I'm not that memorable because we did 3 first.
We did?
Yes.
Who else?
I can't remember the names. One was with Ms. Ronan and
Small pond.
Salem.
Oh, wait. All right. So
And then there was another.
It's a small pond, right? Mastad pointing out that Bradl and Gubitosi are friends, and Gubitosi and Karp have had many trials against one another. But you know, when there's a judge, and you got to put it on the record that the judge says, I can be impartial. Here's the nature of our relationship. I can be impartial, but it's a small pond. These people are going to meet each other over and over and over and over again, right? And that's why. But I seem to remember, wasn't in the Karen Reed civil case also, there was a judge, and they all said they were comfortable with him. I don't know. I could be conflating everything, and it's quite possible. What a freeze frame that is, huh? What a freeze frame. Well done to me. Ecstasy.
One here,
Yeah,
I
in
can't
front of
remember
Judge
the-
Welch. And,
Right,
you know,
right.
I wasn't counting the ones where you were second seating you were like second seating
Correct.
a more junior attorney, but I do remember one in which the two of you prosecutors beat me up pretty good. It was here in this courtroom.
I remember that.
I had made a mistake and opened the door to something, and it was Mr. Gubatosi's fault, because all of a sudden that sidebar, you hadn't said two words during the trial, but raised the issue, but in any event, listen.
Lawyers love to tell war stories. Lawyers love to tell war stories. And especially plaintiffs' lawyers. There's like big swing and D contests. Oh, what do you think about this case that I got? You know, guy falls off a scaffolding, 8 stories up, and he's like a quadriplegic. This is like the kind of like stories they love to tell each other in their braggadocious ways. Not me, I'm not like that. But I can tell you from like, that's what the plaintiff's bar is like. And that's what these guys are like too. Remember that time, the good old days? All right, blah, 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 blah.
I respect both of you folks. I said on the record, I don't know Ms. Coakley. I don't believe professionally. I think that you may have been the chief of a unit in Middlesex at the same time that I was the chief of the domestic violence unit. I think we may have traveled in the same circles, though that would have been decades ago. But I don't think that.
He was the chief of the DV unit. That's interesting to me. Could work either way. Chief of the DV unit.
Here before me, I don't think we ever had cases against each other. Again, I respect you as much as I know you, and in any event, I think that's full disclosure. I'll also just say, as for Dr. Zeisel, you said Dr. Zeisel is not going to give you. Correct. Okay. So, because I think I already mentioned it, he was someone that I used often when I was in practice. So, but it's been years since I've seen him. All right. So, is that sufficient? Did I address? Okay. All right. And the bottom line is, I am confident that I can be fair and impartial. I would not accept the waiver, frankly, if I thought that there was some risk that some favoritism would potentially come into play, or if I thought that I couldn't divorce myself from information that may not be admitted at the trial. Okay, so
He would recuse himself.
I'm very good at compartmentalizing.
He would recuse himself, unlike Judge Cannoni.
I will only consider evidence that's admitted at the trial. All right, and then we'll talk about mechanics and all that afterwards. Let's go through the colloquy. I'd like to, before we have the colloquy, can I see counsel and Ms. Fitzsimmons and sidebar for anyone?
Okay. For the colloquy, I'm going to jump to court chop. Tell me if this audio is better, because that's where I believe it starts. Okay. Thank you, Court Chopped, for chopping this up for us. Now the judge has to question Kelsey to make sure that he is satisfied that she knows what she's giving up by giving up a jury trial, and that he is satisfied that she's doing that knowingly and with her free will. Nobody's forcing her into it.
Better, quote unquote, connections.
Seeking to admit a number of text messages between the
I mean, what had
defendant.
happened was,
Good morning, Your Honor.
Good morning.
March 18th, 2026.
wait, they had the whole thing? Okay. Well, I didn't know that, but here we go.
Attorney Coakley is
The screenshot, I got confused by the initial screenshot that came up when I first pushed play. Tell me if the audio is better here.
Fitzsimmons ready to proceed. Doesn't she pick the witness stand of the waiver?
Yes, she is, Your Honor.
Why doesn't she pick the witness stand
And we can pull a chair over for you, Ms. Attorney Coakley, if you'd like.
Please stand.
Please. Ms. Fitzsimmons, could you raise your right hand? You solemnly swear to make true answers to such questions put by the court or upon its directions to help you God.
Yes.
Okay. Good afternoon. You have a seat.
Good afternoon, Your Honor.
You could put yourself right up to that mic. So as you know, I'm Jeff Karp, and I'm a judge here at the Superior Court. And I understand that you'd like to give up your right to have a jury decide whether you're guilty or not guilty of the charge. And I need to just ask you some questions to make sure that you understand the rights that you're giving up and you're doing it voluntarily, okay? And that you know what the consequences. Now, so I'm going to have a lot of questions for you. If at any time you don't understand something that I say to you, it's perfectly fine to interrupt me and tell me I don't understand. If at any time you'd like to take a break and speak with Attorney Coakley, we can give you that opportunity. We're in no rush here. It's very important that you understand all that I tell you. And yeah, okay. All right. So first thing I'd like to do is where's the indictment, Mr. Boyne? I just grabbed that. So you understand that you're charged in a single indictment with the crime of assault by means of a dangerous weapon. Do you understand that?
Yes, Your Honor.
Okay. And do you understand that have you discussed with your attorneys what the Commonwealth needs to prove at the trial for that charge?
Yes, Your Honor.
Okay. And you feel as though you understand what they've told you about that?
Yes, Your Honor.
And do you understand that charge, assault by means of a dangerous weapon, carries up to 5 years in state prison if you're convicted?
Yes.
Okay. And sorry.
So if she's convicted, it could carry up to 5 years in prison. But we've talked about this before. Under the guidelines, the sentencing guidelines, because she doesn't have a record, except for some, I don't know, ticket for underage drinking when she was in 2018 or 2017, that under the guidelines, she would be entitled to 5 years probation, likely would not serve jail time. She's already served 103 days in jail. So she's already served more jail time than she likely would be sentenced to, but that's never a guarantee. And Kelsey needs to be advised of all of these things before she knowingly waives her right to a jury. And that's standing next to her is Martha Coakley. She's the former Attorney General for the state of Massachusetts, who is on the defense team.
Well, Attorney Coakley, either you or Attorney Bradl have gone over the elements of the charge with Ms. Fitzsimmons.
Yes, Your Honor, we have.
Okay. All right. So I need to just ask you some background questions to get some background information. Some of this I already know, but I still need to, I need to ask you formally. So if you could state your full name.
Kelsey Fitzsimmons.
And how old are you?
I'm 29.
What is just your month and year of birth?
11/18, November 18.
And where were you born?
Concord, Mass.
How far did you go in school?
I got my bachelor's degree and I went to half of law school.
Okay. You went to what?
Half. I did
Half
half.
of law school? That's enough. Was that enough for you?
No, I'm gonna go back.
You're,
She says she's going to go back to law school. She's been to half of law school, so that would be a year and a half. It's 3 years. Maybe it's 4 years if you go to night school. But she says she's going to go back.
you're thinking about going back.
I am.
And you said you got a bachelor's degree in.
However, it's important to point out that if you are a convicted felon, you're not allowed to be admitted to the bar, at least in New York.
What?
In criminal justice.
Criminal justice, and where from?
Where am I from?
No, where did you get?
Oh, I'm sorry. I'm nervous. I'm sorry. Fisher College in Boston.
Okay, all right, and totally understandable that you're nervous. All right, and again, some of this I know, but I have to ask, what are you? You can't be presently working, right? You're not working now.
No,
All
you're
right, and your last job was with.
patrol officer with the North Andover Police Department.
Okay, and how long were you there, roughly?
About a year and a half, if you count the academy.
Okay, so you went to the police academy and
Yes.
and what else? And just normal job duties as a patrol officer in North Andover.
Respond to 911 calls, emergencies, medical emergencies, calls for service in the town.
Okay, all right, and
Did you take any prescription medications, over-the-counter medications, or drugs in the last 24 hours?
Yes, I have.
Okay, and what have you taken in the last 24 hours?
In the last 24 hours, I've taken fluoxetine,
Okay,
hydroxine,
okay,
and lorazepam.
all right. And
Lorazepam.
any of those medications
Watches White Lotus. Wasn't it? She always wanted a lorazepam.
or have any of those medications affected your ability to understand the proceedings today here?
No, Your Honor.
All right. And did you consume any alcohol in the last 24 hours?
No, Your Honor.
And have you ever been treated for any mental health?
Yeah.
Okay. And do you feel as though that you're suffering from any mental health condition today? In other words, that like right now, as we're going through this, that you're feeling some effect of any mental health condition?
No.
And do you feel as though your mind is clear today?
Yes, Your Honor.
And have you understood all that I've discussed it open court with the attorneys about, up to this point, about even like the motion to admit the text messages. Have you understood all of that?
Yes, Your Honor.
Okay. And so I'm just going to go over your constitutional rights. So you have a constitutional right to one trial of the charge. And you have the right to choose whether to have a trial before a jury or a judge. At a jury trial, the jury decides whether you are guilty or not guilty of the charge. And the judge's job during the jury trial is to rule on legal issues that arise during the trial, to instruct the jury on the law of the case, in other words, what the Commonwealth has to prove, and to impose a sentence if the jury were to find you guilty. So that would be the judge's job during a jury trial. But the jury would decide whether or not the Commonwealth proved that you are guilty beyond a reasonable doubt. All right, you understand that?
Yes, Your Honor.
And at a jury trial, you have the right to a trial here with 12 jurors. These are people selected from the community. You'd have the right to participate in selecting jurors. And you could not be found guilty at the jury trial unless the Commonwealth convinces all 12 of those jurors that you are guilty beyond a reasonable doubt. So do you understand all of your rights and how a jury trial works?
Yes, Your Honor.
All right. And also you could choose to have a trial by a judge instead of jury. And in such case, the judge cannot find you guilty unless the Commonwealth convinces the judge that you are guilty of the charge beyond a reasonable doubt. Do you understand your right to a judge trial?
Yes, Your Honor.
Do you understand that by waiving your right to a jury trial, the judge will be me? I will be deciding whether the Commonwealth has proven the charges.
Now we know he's definitely handling the trial. It was a little up in the air there for a little bit.
Understand that?
Yes, Your Honor.
Okay. And you understand that by waiving or giving up your right to a trial by a jury, that I just already told you. So do you generally understand the difference between a judge trial and a jury trial?
I do.
Okay. And do you have any questions at all about the difference between those two types of trial?
I do not.
Now, let's send you this. And I'm showing you a form called a defendant's waiver of jury trial and consent to trial by judge. Did you read that form?
I did.
Did you discuss it with counsel or the attorneys?
I did.
All right. And did you sign that?
I did sign it.
Did you understand that the form says in writing what you and I have been talking about thus far about giving up your constitutional right to a trial by a jury?
Yes.
Okay. Did you sign that form voluntarily?
Yes, I did.
And by signing the form, are you saying in writing that you know about and understand your right to a jury trial, which is explained on the form, and that you voluntarily give up that right?
Yes.
All right. And you now willingly and voluntarily waive your right to have a jury decide your case instead to choose. You think that I have never done this before. Maybe I'm the one that's nervous.
I've never no. Okay.
Let me start over again. Do you now willingly and voluntarily waive your right to have a jury decide your case and instead choose to have a judge, being me, decide if you're guilty or not?
Yes.
And do you understand that your waiver of your right to have a jury decide your case is final, and you cannot change your mind and ever ask for a jury trial again in this matter? Do you understand that?
Yes.
Has anyone threatened you or forced you in any way to waive your right to a jury trial?
No.
Has anyone promised you anything in return for your decision to waive your right to have a jury decide the case?
No.
Have you had enough time to fully discuss your right to a jury trial and the difference between a jury trial and a judge trial with your attorneys?
Yes.
Do you feel as though your attorneys have acted in your best interest and that they have fully and adequately explained your right to a jury trial and the difference between the two types of trials?
Yes, Your Honor.
Have you been confused by anything I've said thus far during this colloquy?
No.
So as I understand it, then you're waiving your right to have a jury decide your case, and you're choosing to have me, a judge, decide whether or not you're guilty because you want to and because you believe it's in your best interest to do so. Is that correct?
Yes, Your Honor.
And the defense, any additional questions?
Understand that everything that he is reading is from like a book. Like he has to ask her all this stuff. It's not extra. He's not just, ad-libbing. These are all required instructions and part of the colloquy that's required when a defendant waives a jury trial. It feels extra because sometimes when they do the colloquy about not testifying, they do it outside the presence of us at sidebar. And so it seems longer, but these are all things that he's required to say. It's a script, yeah.
Well, no, thank you. None? Okay. All right. And does the defense or the Commonwealth know of any reason I should not accept the waiver?
No, Your Honor.
Okay. All right. You may step down. Thank you very much.
Thank you, Your Honor.
All right. I'm going to make the following findings. Yeah, Mr. Roy, can take that. Thank you. So I'll make the following findings. I find that the defendant, while she is presently or has taken medication, prescription medication in the last 24 hours, I find that that medication has not affected her ability to understand and participate fully today. I also find that although the defendant, Ms. Fitzsimmons, has reported that, or at least, I don't know if she reported it, but I do know that at least in the past, she suffered from mental health conditions and that perhaps some of that medication is related to that. I do find that any mental health condition that Ms. Fitzsimmons may have had or has not affected her ability to understand and participate fully in the proceedings here today. I further find that Ms. Fitzsimmons understands the nature of the charge against her and the consequences of waiving her right to a jury trial. I find that the decision to, I find that Ms. Fitzsimmons' decision to waive her right to a jury trial is made with the advice of competent counsel. And finally, I find that the defendant's waiver of her right to a jury trial has been made knowingly, willingly, intelligently, and voluntarily, and with the full knowledge and understanding of its consequences. And accordingly, I accept Ms. Fitzsimmons' waiver of her right to a jury trial. All right. With that in mind, so anything you folks want to go over, but I anticipate we'll just start on Monday morning. Are you prepared to? Because maybe you're not, but given that I had said that.
Sure, I hope to be. I mean, that was the plan for all our witnesses, but we'll reach out today and make sure,
Okay.
or ensure everybody that we can have is available Monday.
Okay. All right. And so let me say this. I realize that from both sides' perspective that, trying a case, whether it's jury or not, is like trying. It's difficult herding all your witnesses together. I usually try to make a joke about it's like herding fish or something, but Mr. Hubertosi's heard that a few other times. So, but in all seriousness, we will, Ms. Roy, we're going to go full days.
Yep.
And to the extent that you run out of witnesses on a day, that's just life. That's fine. Do you expect now with this new, let me ask, with the new kind of schedule where the actual evidence and trial is going to start earlier, expect any witness availability issues?
Well, everybody was free for the week, so no, I mean, I don't anticipate whether somebody is available Monday in particular.
Okay.
We'll find out.
All right. So it is my anticipation that however we proceed, that the trial will be over by Friday. Is that a good, fair schedule or fair belief that I hold, I guess?
Yes, so
Okay.
So it'll be over by
Okay, so-
Friday. Massad says one thing Karp won't do is render a verdict right away. Expects him to take a few days. That's interesting because we watched Judge Cannoni from a bench trial acquit Penny McGee. If you haven't watched that trial, you should go back and watch it. The bench trial we covered recently on Ruth Miller was interesting because it was only done on papers. And so the judge just reviewed expert reports and some other evidence that was submitted on paper to him. And then he just, on the day of the bench trial, came out and issued his verdict. Trying to remember any other bench trials that we've covered recently. Remind me in the chat. But Cannoni shockingly ruled from the bench right after it was over. I guess anything is possible. So they said they're going to be done by Friday. That fits into my schedule so much better than a potential 12-day jury selection period. Because the judge did say, listen, in my opinion, he said it's going to take at least 2 to 3 more times the days to pick a jury than it will to actually try the case. And so let's see, my anticipation
that however we proceed, that the trial will be over by Friday. Is that a good, fair schedule or fair belief that I hold, I guess?
yes, so
Okay. Okay, so we'll
done by
just
Friday.
start up on Monday morning. All right. I'm gonna see you folks.
Aiden had a bench trial against Lindsay for violating the restraining order. That's right. Who was that judge? He also ruled right from the bench too, right?
Yeah, sorry, I just wanted to point up something for you that you were talking earlier about jury instructions and instructions that you would take into account yourself. And there's one slight, maybe a curveball. There's a code of Massachusetts regulations. Okay. I just want to give you the citation. It's 555 CMR 6.05 parentheses 3 close parentheses.
All right. So let me say this. I don't know exactly what you're referring to, but maybe it makes sense for me to just explain. So what I will ask is that you folks submit, they can be in the form of jury instructions, but just,
Judge Pomeroy.
instructions that I will use when I deliver as to the law, assault by means of a dangerous weapon. So whatever it is that you're referring to, Mr. Bradl, you should just put in that document again, whether it's however you want to type it on, but
It's from the post-commission regulations, Judge, and it's a CMR that states that an officer is not permitted to use deadly force to someone who is a danger to themselves. And that's really the central issue.
Right, but again, without having it in front of me, what is that?
Oh yeah, Bradl's been talking about this since the day Kelsey got arrested. I mean, Bradl's been screaming this into a closet since his first statement on this case. Excessive force. That it's in the regulations, the police regulations. I'll pull it up after this. That an officer is not allowed to use deadly force, 6.03, 6.05 sub 3. Boop. Use of deadly force, right here in black and white. An officer may not use deadly force against a person who poses only a danger to themselves. But that's not, this isn't new that he's raising this because we've known about it since the beginning of time, at least when I first started covering this case, which was in July 2025. Maybe 11 days after her shooting, whenever he made his first statement. Okay, here we go.
that have to do with whether the Commonwealth will be able to prove that the allegation is that Ms. Fitzsimmons committed the assault by means of a dangerous weapon. So I'm not following.
I think it has sort of a general import where if
Noonan's not on trial, right? Noonan's not on trial here. Apparently there was some sort of an independent investigation, but he's not facing any charges. And so is it relevant? I mean, he's just putting the judge on notice of it.
if the court has a reasonable doubt as to whether or not Ms. Fitzsimmons was engaging in conduct that was harmful only to herself, it does not, by law, excuse the Officer Noonan shooting her.
Frankly, I understand, but well,
That's
so
not even
let
an
me
issue,
just
though.
hold on one second, Mr. Brady.
I mean, am I missing something? Because Noonan shooting her is not really an issue. I mean, it will be if she files a civil lawsuit and can get around immunity and all of these other things. Because what has come out recently is that Noonan went AWOL one day and the department went and did a wellness check on him. And he said, oh, I took a Flexeril and I didn't wake up in time. And now he's been suspended, right? Didn't we also learn that he's not on active duty? Maybe not suspended, but he's not active right now. We're not sure why. But the defense has asked for his records. And Noonan said, I have nothing to hide. You can have them. And then we found out that he's not active right now. So there's a lot of interesting things going on here. But the central issue is whether or not Kelsey pointed that gun at Noonan. That's really it.
What I expect is that perhaps at the end of the evidence and even before closings, we'll have a charge conference. We'll treat it just like we would in a jury trial, and you folks can make your pitch on the law, but I will want some submissions on the law that I should be, again, as it relates to the charge and the elements and things of that nature. If there's some defense that you're asserting related to that, you can, perhaps that would be a mechanism for raising that. All right, but I right now, I don't understand it, and I'm not sure that I need to at this point. Okay, anything else?
Your Honor, do you start at 9 a.m.?
Yes, I'd like to. We do our best to start at 9. Mr. Wayne and I are always ready, but
I know Mr. Wayne, we got early. It's
but Mr. Wayne and I seem to be the only ones that are ready at 9, but. Yeah.
And just folks, 9 to 4 is a full day for the court. I'm just,
Right.
Okay, thank you.
It is. And like I say, if you folks can disclose to one another what witnesses you think you're going to be calling on a given day, and that would be.
And with your permission, I think we should be able to pre-mark a number of exhibits. Okay.
So you'll work that out with Mr. Wayne, that would be great. Also, if we need to take a defense witness out of order, certainly we're here, the Commonwealth, if there's opposition to that, but even for a jury trial, I typically would allow that. So again, if it's a scheduling related matter, not a strategy related decision, but if there's some scheduling conflict that will help to proceed. All right, so we will see you folks on Monday morning.
Thank you.
Thank you, Your Honor.
All right, we're going to be gavel to gavel on this one starting Monday morning at 9.
I'm going to,
Jen says Noonan has a motivation for it to be that she wasn't pointing it at herself because he risks consequences with post based off of that CMR if it's opposite. All right, let's take a look at the text messages, shall we? It's really going to shorten the length of time for this trial, and it gives us all who cover this we can plan better. We can plan our days better because we don't have to factor in jury selection, and you never know how long jury selection is going to take. And so it's kind of like we're in a holding pattern until the trial starts, and then we're in a holding pattern during deliberations. And so it makes it easier for those of us who are here on the internet bringing these cases to you, and I will allow it. I will allow it. Let's go to the chat for a minute. Take off the banner. It's me, love the empowerment card today. Thank you, thank you, thank you. It says, may your coffee be hot and your eyeliner be even. Thanks for 5. Kelly says, North Andover PD and the Commonwealth are doing what I call Teflon turtling, covering their own backs and hoping nothing sticks. Thanks for tuning in from across the pond. Lulabelle has been here for 4 months. I hope Kelsey gets that law degree and sues like hell. Deshaun wants to go over Chris Albert's exit speech. Let's do this in order and see how much time we have left afterwards, but I will keep that up. And thank you, Gen X. Thanks, ZCA, for gifting 5 memberships. You're amazing. You're amazing. All right, let's take a look at these text messages that Justin provided the Commonwealth with and see whether we think they help or hurt Kelsey, and go to the issue of whether she pointed her gun at herself or at Noonan. Elaine wants to know, do you think that Noonan was drug tested? I think that would be relevant after an officer involved shooting. I do not know. I do not know. We do know that there was some type of an independent investigation, but law enforcement in the chat, Scott, if you're here, is that something that would typically be done automatically after an officer involved shooting? Would they be taken back to the station, or when they reported back, would they be drug tested? 25 years on the job. Let me know. I mean, there's always an investigation done, right, with an officer involved shooting. Yes, of course, they do call witnesses, Susie Q. That's a good question. They do call witnesses. It's like a regular trial, except there's no jury. And so the judge is the finder of fact. Will there still be things at sidebar? Yes, because there's public in the courtroom and there are cameras in the courtroom. And so there could be objections that need to be argued at sidebar that won't be done in front of the whole entire world, like we just watched in the Afroman trial. That was crazy. Oh, okay. Scott said that he needs to find. He would need to find. He tried to find out what the procedure is in Massachusetts and couldn't find it. In New York City, it's automatic. It's automatic that after an officer involved shooting, the officer would be drug tested. Do you think Kelsey will testify? I don't think she will need to with trial by judge. Can't wait for Justin to take the stand and see him squirm. I think she will. I mean, it could be a game time decision, but Noonan's going to say she pointed the gun at me, and there's nobody else to say she didn't, except for Kelsey. But I do think that a judge will be able to listen to her testimony in a more unbiased way than a jury would, because juries look at facial expressions, the way she's sitting, whether or not they like her, whether or not they think she's pretty or dressed appropriately, right? And so I do think she needs to tell her side of the story. It's a he said, she said. Can't wait for Justin to take the stand and see him squirm. I don't think anybody's going to call him, but that remains to be seen too, Lola. So we'll see. Thanks for your 5. All right, let's, and she wants to testify. I think she said it. She wants the truth out there. Oh man, these text messages are small. All right, we're going to have to really zoom in on them. Let's just see. All right. Oh man, they're really testing my eyes now. Okay, so these are text messages between Justin and Kelsey on the 30th of June, beginning. What looks like, I mean, does that say Monday, June 30th at 3:23 p.m.? Can anybody read that? So tiny. All right. So this would be Kelsey on the left and Justin on the right, because they're from his perspective, because they came from his phone. I know, it's crazy. Kelsey says, you just woke me up to let me know I have to bring the baby to work with me. Justin says, you were not listening then. I will happily pick up the baby and watch him at work. I said, I don't want to be in the house at this time. You have to respect that. You are choosing to not have me watch him and bring him to work. Kelsey says, you're not a babysitter, you're his dad. This is our home where the three of us live. Yeah, and now thinking about it, he may have to take the stand to show that these are his text messages, unless for some reason the defense agrees to stipulate to allow them in. But you know, your strategy could shift based on the fact that it's going to be a bench trial and you're not trying to influence the jury so much or color the jury one way or another. Terry says, I'm not sure a bench trial is better. Seems a jury would be way more understanding and sympathetic. Or there are certain jurors who just believe cops no matter what they say. And the cop they believe may not be Kelsey. This is a highly emotional case, highly emotional. And so hopefully the judge is supposed to be able to separate the emotion from the testimony. You are choosing to not have me watch him and bring him to work. Kelsey says, you're not a babysitter, you're his dad. This is our home where the three of us live. Again, Monday, June 30th. Justin has said he didn't live there since the 27th. This could work against her because she's saying this is where the three of us live. But again, that's more family court stuff than this particular trial because they're not getting into the breaking and entering here. The date of the shooting is this exact same day, June 30th. Justin says, and by being his dad, I will watch him and pick him up if you wish. Kelsey said, you're not a babysitter, Justin. You don't watch him. You can simply just come home and be home with him. You know, the home where our family lives. And that's why Justin wanted these. That's why Justin wanted these messages out there, because he wants everyone to think he didn't break into the house. In my opinion. Justin says, right now, Kels, those are the options. I will and can pick him up to be with him while you're at work, but you're choosing to bring him to work. You have to respect that I need space and time and will not be entering the house alone. Right? Not until you're fighting for your life in the hospital. Kelsey says, your space is abandoning your family. I don't understand why you can't come in our house and you won't explain it. It will not be single parenting for days on end. Justin says, when you strike me in the face several times and physically assault your best friends, Kels, you set the tone. Okay, that's going to be redacted. I'm reacting in the best way possible to find a way forward, and this is what I need. It's not about what you need anymore. We need to be the best parents possible, and I can't do that in the house at this time. And remember, when he went to get his restraining order, that's what he claimed. He claimed that she hit him several times and that she also assaulted her best friend. And Kelsey says, just not even true, but okay. Abandon your son, thumbs up. I forgot everything that comes out of Katrina's mouth is the truth, right? I don't know who Katrina is. Good luck to you. Kelsey goes on to say, you're missing valuable. Oh, wait. And then he goes on to say, because he's telling us everything, it's not redacted. And Cassie and DeAndre and Michelle are all lying. His mom's name is Lisa. Kelsey says, you're missing valuable days with your son. You will never get back by your own choosing. You're making me a very single mother by your own choosing. Kelsey says, I'm rescheduling the baby's surgery right now. I will not be doing this alone. Answer the phone. So I guess she started calling him. And he's blowing her off. Sad that you let your feelings toward me affect your son. Poor kid. And then she continues on, but there's no timestamps on here. So we don't know if things have been deleted. Sad that you let your feelings towards me affect your son. Poor kid. The purest innocent soul gets affected because you won't help me fast him. Would you like to tour his daycare with me? And Justin says, no, my mom has offered free daycare. We do not have $500 a week for daycare. Oh, there it is. There it is. Mom wants to watch the baby, so they don't pay money on daycare. For daycare, mom wants to watch the baby. A lot of people think she was the driving force behind this. Darlene's opinion is that Katrina was her friend who took his side and lied about hitting him. She may have had a fling with just a liar, in my opinion. We don't know. A lot of people think that Lisa wanted the baby. Have you seen the baby? Do you want to see the baby? Kelsey says he's going to daycare. Don't worry about the money. It's taken care of. I don't think Kelsey wanted the baby with Justin's mom. Justin says, who's paying for it? Kelsey says, it doesn't matter. Do you want to tour it with me or not? Justin says, well, it does matter. Kelsey says, it doesn't. If you want to come, great. If you don't, great. Justin says, you want to place a 4-month-old baby into daycare? Kelsey says, I am, yes. Do you want me to pack your stuff and move it out? I'm going to have to sell my house and find an apartment. Justin says, I need my debit card and license you took right now. That's it. Kelsey says, don't have it. Why would I have that? I'll leave all your stuff outside. I have to put my house on the market. I guess she means that if he's not living there to contribute, she can't afford to live there. That's what it sounds like. And Justin says, please do not touch my belongings. How many belongings did he have in there that he told the PD it was going to take him and 5 guys hours to get his stuff out? And Lisa is in Stowe. Andover is not convenient commute. Thank you. Thank you, Double Trouble. I don't know how far away it is, but thanks for your deuce. Kelsey says, I have to put my house on the market. I can't risk being in a situation I can't afford because you have told people you are leaving, but you haven't told me. That's interesting. He's telling everybody else they're breaking up, but he hasn't even told her. And that day he went into court to get the order. Justin said, who on earth have I told that to? You keep making things up. And she says, not me, that's for sure. Oh, really? I made that up? Okay. If you're leaving me, you need to tell me so I can figure out my life. Not tell others, tell me. And he says, I need space and time right now. I don't have a plan. I just know I need space and time. Pass the duchy around the left-hand side. Oh, no, that was my addition. And Kelsey says, okay, that tells me nothing. After your space and time, are you leaving? Because I need to come up with a plan. You're not going to leave me in the dark on my own life. Okay, that's fine, Justin. Don't answer me. I'll put your stuff outside in boxes, of course, get an attorney and sell this house. I'm not going to be set up. What does that mean? I'm not going to be set up. To the left, everything you own in a box to the left. That's what it reminds me of. I'm not going to be set up. This is my life. Did she have the feeling that he was setting her up for something? Okay. This is my life. Am I paying our venue the $6,000 or should I hold off? I guess they were paying off their wedding and they needed to put a $6,000 payment to the wedding vendor or venue. And Justin says, only $1,500 was left to pay and I sent you that already. Kelsey says, I have $6,000 waiting to send him. It's due July 4th. If I send it, we cannot get a refund. We can't get a refund on anything. Would you like me to send it or hold off? Sounds like he wants to call off the wedding and he's told people that he wants to, but she doesn't even know if she's getting married anymore. He says, I think we're under contract to pay it regardless. He's being a little dick. She thought he was going to set her up and he did. So what am I doing? Justin says, can you send me the contract? And she says, no, I don't have it. Regardless, if I talk to Gene, I'm sure he will let me keep the money. Do you want me to send it or not? It's a really simple question. And because there's no timestamps on this, we don't know how long it is in between messages. We don't know. And that's why these don't seem legit to me. And then he says, not yet. I don't know. And then she's got a laughing, crying emoji. And she says, tells me everything I need to know. Thank you. I'll send it to my parents now for their troubles and call Jean today. I guess Jean is the wedding planner or venue person. He says, Kelsey, that's not what I'm saying. I don't have any answers today. Kelsey, just hold me for it's not due until the 4th. That was the day she was scheduled to go back to work. Remember, July 4th, she was cleared. And then Kelsey says, I'll meet you at the Common at 2 p.m. Wasn't the original story that Justin asked her to go to the park? I don't know if these are tweaked. I don't know what's going on. She says, I'll meet you at the Common at 2 p.m. And then she says, what do you mean? For what? On the phone, you said we can meet up in public or go for a walk. I'll see you at the Common at 2. All right, so he must have said that on the phone. And then this is Monday, June 30th at, I have no idea, this is 11 a.m. So were those other messages at 3 a.m.? Hold please for 1 second. I mean, this purports to say Monday, June 30th at 11 a.m. But when we looked up there, was that at 3? Are they talking in the middle of 8 a.m. for the others? Thank you. I couldn't read it. All right, so now it's 11:52, 11 something a.m. She said, on the phone, you said we can meet up in public or go for a walk. I'll see you at the Common at 2. And then something is redacted. Maybe it's with the baby. And then at 11:52 a.m., he says, Kels, I have no debit card, no license. My gas tank is empty. And I couldn't get money this morning to drive to get the baby. But Lisa and Doug are both gone. Oh, those are his parents. He calls them by their first names. That's kind of weird. Lisa and Doug are both gone for the entire day now. I have no way of getting out there now. Can we meet tomorrow instead? Unless Lisa comes home and I can get some money for gas. Okay. Other copies have the timestamps. Maybe these are cut off. I got these from a news article. Kelsey says, you don't have enough gas to get here? I haven't gone through any of my bags yet besides my purse, and many of my shit was stolen as well. I will look in the other bags. I didn't even bother touching it because some substance was poured all over it that smells really bad. I will look once I get the courage to go down to the basement. Remember, they had their Jack and Jill bachelorette party. I think it was 2 days before this on the 28th. This is Monday. That was a Saturday night. He says he got mad and left. She probably had to pack everything up and take it with her. And maybe that's what happened. But something got spilled all over her stuff that smells terrible. The less than 50 miles light was on before I grabbed my truck last night. There could be 5 miles or 20, but I have nothing and no way to get there. And Dougie is at work and Lisa is out with doctor's stuff all day, she said this morning. He's saying he doesn't have his debit card and his license. He thinks she has it. Law Girl says, no, I have the motion with the actual exhibits. There are no timestamps. Well, that's interesting. Did somebody add them later? And there's other versions with timestamps. Kelsey says, okay, I'll give you the money in the drawer. I'm going to work now. I'll see you at the Common at 2 with our son. Justin says, the less than 50 miles light was on before I grabbed my truck. All right, well, we got that already. Oh, and she says, see you at the Common at 2 with our son. Justin replies, I don't have gas to get there, Kels. You took my debit card and ID and did God knows what with it. She's saying, Justin, I was chaotically packing bags. I didn't mean to take anything. And he says, but you still did. She says, my bag has stuff stolen out of it. And my other bag has something poured all over it because every piece of my clothing is soaked. I will look through that one right now. Then I'm going to work. And he says, why did you tell me to come over at 10 then for this kiddo if you were going to work now? For this kiddo? Is he meaning his son? She says, because I wanted to sleep. I didn't sleep last night. Why does it matter? I decided to change it to 12:30. In the very bottom of my soaked bag is your toiletries, boxers, and cards, meaning I guess his credit cards. Sorry, I got my bag at 10 p.m. last night and just bawled because my clothes are ruined. My stuff was stolen. I didn't even go through it all the way. I don't know what you're talking about. Can I see you tomorrow instead? You literally work tomorrow. I will see you at 2. And then he's like, shoot, I forgot I work. And she sent a question mark. And he said, I have no way of getting to town. And she says, yes, you do. Hello, Justin, am I seeing you at 2 or not? WTF? And he says, Kelsey, I have no gas. I physically cannot go anywhere. I'm looking for change around the house And there is none. He's got his red receipts on. That's one thing I can see. And she says, yes, you do. Hello. Oh, wait. Okay. And then she says, how do you have enough gas to not be home right now then? Just in it for the money. I can't go to work. I'm done. I'm done. Answer the phone. So you're out. That's why you won't come see me. I'm done. I'm driving up to the land. I'm going to my land. I guess she owns land somewhere. And he won't answer the phone. This reminds you of Karen Reed getting ramped up when John wouldn't answer her one of however many phone calls that she made to him that night. Where are you, Justin? Justin, what is going on? I'm worried. I'm really worried. Justin, are you okay? So this is at 2:02 p.m. Monday, June 30th, when I guess she's waiting at the Common. But she said she was going to her land, so I'm confused. Right. Doesn't he have Apple Pay? Exactly. Why are you at Hunter's with your sister? What is going on? Is Hunter's a place or a person? Does she have his location on her phone? Does he share his location with her? I thought I was meeting you at the Common. What is going on? All caps. What is going on? I'm literally shaking. Why are you with girls at Hunter's house? I guess Hunter's a guy. We were supposed to go for a walk with our son. What the F is happening? I'm throwing up. Why are you with Katrina? What is going on? Oh, Katrina, was she a bridesmaid? Why are you doing this to me? She saw cars at Hunter's on the way to the park. Thank you, Drop Microdots. Knows all the details. Thank you. Why are you doing this to me? Why are you doing this to me, Justin? What are you doing to me? What are you actually doing to me? Why are you with Katrina? I just need you to communicate with me. That this is not fair. You made a plan with me. No, was he having a thing with Katrina? Did she suspect him of having a thing with Katrina? Is she now being gaslit? Kind of sounds like it. I just need you to communicate with me. This is not fair. You made a plan with me. Making plans with me and your son and ghosting me is just so mean. I'm going far away for a long, long time. You could have at least told me you changed your mind instead of standing me up and making me wait at the Common for 2 hours. Just really mean. Also crazy for you to just read all my texts. Know how upset this made me. You don't love or care about me. This is so mean. Why wouldn't you just tell me you changed your mind instead of standing me up? Her mind is reeling. If you drove there with Courtney, you clearly had no intention of going for a walk with me or your son. Why would you make plans with me? Why would you make plans with us? I packed his diaper bag and stroller and a blanket for us to sit on just to be stood up. Why be mean about it? Why not just say, sorry, not happening anymore, change my mind? Like you called me saying you were on your way to North Andover. Your mom gave you money and you would see me at 2. Oh, well, that's what we're missing is the conversations. So he must have called her and said his mother gave him money. Lisa gave him money. So he was on his way to North Andover, but I think he was really going to court. Somebody said Katrina can have him. He's a loser. WTF happened since that phone call. If you're trying to hurt me, you're succeeding. I feel really effing hurt. I just want to know why you made plans with me and the baby and stood us up. Why couldn't you just have said, never mind to me? Not have me wait and wait and wait at the Common for you. And something was edited there because it says edited. Ignoring the mother of your child and fiance, I don't get it. I really do not. You made it very clear I'm not your family. I will pack your belongings and put it outside for you to retrieve. I'll let you know when it's all outside. Need to get some people to help me move it all. You didn't have to lie to me and say you were meeting me. You didn't have to lead me on to think we were going for a walk. I don't know what that did for you. Why didn't you just tell me? Why did you have me sitting at the park alone with our son waiting? You knew the only way from the station to the park is to drive by Hunter's. If you did this to hurt me, it worked. I told the baby we were going to see daddy. Your not just hurting me. You're not just hurting me. And for you, to this point, to still give me nothing and say nothing, you set up this huge plan to make me think my son and I were going to meet you for a walk, and then you ghosted me. I hope you know that hurts a lot more than just me. You ditched seeing your son. Like, why? Why couldn't you have just said to me that you never had intentions of seeing us? I sat and waited at the park until his bottle ran out and had nothing more to give him. Why couldn't you just have called me and said you changed your mind? Why do it like this? And you're not going to say your phone is in the truck, because when you click on your messages, it shows you read it. You're mean. You wanted a reaction from me. You won't get one. I'm on my way up to my land for the night. I love you. I'm sorry. I'm so shitty of a person that you couldn't even see your son smile today. We're going to our happy place. I'll send you pictures when I get service. Talk to me, chat. Talk to me. China Tonk says this is enraging. Wendy says it's heartbreaking. Julie says, what a jackass. Law Girl's Not Attorney says, so he wanted her to see his truck at Hunter's and Katrina's car too. What time did he go to court that day? I mean, was it probably around that time? Yeah, many courts shut down at 4. I don't know if this one shuts down at 5. Katrina, what are you doing here? Law Mama 4 says, Kelsey presents so professional in court. These messages tell me the only way he could win was to set her up. She would totally present more fit against him if this criminal case didn't exist. KLAJ says she isn't even being mean in these text messages. She's hurt. And then what happened? Then what happened is she goes home and there's a knock at the door with 3 of her coworkers with Justin has a restraining order against you and to take away the baby order. Here you go. And based on these messages, what do you think she thought at that moment? Her baby's being taken away. She's definitely not getting married now. And this guy had the cojones to go to court and get these orders against her while she's waiting in the park for him. Would she be more likely to want to shoot Noonan or herself? I think these help her defense. Double Trouble says they said he's going to read the text, and no, I believe so. Lola says Justin may not have gas money to get to court. Music to My Soul says, I think Bradl could use that regulation to help discredit Noonan's testimony because he has an interest in claiming that Kelsey pointed the gun at him. Could go to his credibility. Yeah. Agreed. Thank you. That's an excellent point. Burp Snart says he wanted to go to court before she could. That's all that was. As soon as he said lawyer, as soon as she said lawyer, he probably told his mom, and they went to set things in motion. Well, we have the audio. Thanks for your super chat. We have the audio from the PD. We can hear Justin talking. You want to hear that next? It sounds to me like this was a toxic relationship with Justin, and I feel that she should be lucky that she didn't marry him. That's my opinion. I'm sticking to it. Thank you, Lauren. Thank you, spam message from the official DMV notifications are so ridiculous. All right, hold on, spam. Some of these, I want to get to like the good ones because some of them are just like quick hangups, right? Okay, hold tight. Let me see if I can open it this way, if it'll share the audio. Okay, let me know if you can hear this. Oops. All right, well, that's, oh, come on, man. Hold on. I may have to do this a different way. Do, 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 do. You can't hear it, right? Let me see if I can do it another way. All right, I may have to download each of these, and it's a pain in the neck. So hold on one second. Did you guys already hear these? Because Baker did a really good job with them, but I just want you to hear. I just want you to hear one or two. Talk amongst yourselves for a second. Lauren, I can't open these the way you sent them to me. Let me see if anybody else sent them to me. Hold on. I'm going to refer you over to Baker, but it's kind of like he is exactly the Karen that we thought that he was when he wanted to speak to the manager. And so we can maybe go over these tomorrow if I can find a different way to open them, because I have a new system and I don't have all the programs installed and it's a whole freaking thing. Let's look at, while I work on that, let's look at Chris Albert's farewell speech from the Canton Select Board and how he turned this into a thing about himself. It's crazy if you haven't seen it. Let's do that first. Talk amongst yourselves for a second. Yeah, he sounds like an entitled mama's boy, 100%. In my opinion, that's such. Is there another way to get this video? He can't even read his own speech. All right, here we go. This was at yesterday. No, this is the 17th. So this is St. Patrick's Day. That had a Canton Select Board meeting. And Chris Albert gave his, what seems to be a farewell speech. There we go.
Could have a couple of minutes to read a small statement.
Yes, sir.
All right.
It's Chris Albert.
Since this is my second to last meeting, my time is coming to an end as a member of the Canton Board of the Canton Select Board. When I set out and ran for the Select Board, I did so as a resident of Canton who was raised here, chose to raise my family in this great town, and as a business owner who supported the community, I wanted to give back, and it was my time. What I didn't realize when winning this seat and topping the ballot that night was the hurtful and negative attention that this would soon come my way. Within 24 hours of winning, I watched as members of this community, a former select board member, current select board member, and other members of the community immediately got to work of their goal to take the select board back. These were their words, not mine. This is fine, and I support them for that. I guess there was frustration that a community member who was a little bit of a conservative would win a seat in Canton. That irked many. Personally, I never look at Canton politics as having left or right. I always looked at it as having members to do work with in the best interest of Canton. Not to force an ideology down the throats of our community. I knew at the time we were going to have some disagreements, and my goal was, as citizens of Canton, we would figure it out, just as those have led the town previously always did, work together as one. Just a few weeks after being elected, my world and my family's world would change forever. And many of the people that were upset at me for winning this election would then turn to welcome a divide to Canton that has never been seen before. Years, members of this community who I've known for years turned their back, first because I won an election, second because they wanted to believe a made-up conspiracy that was funneled by an online blogger enhanced by some members of this community.
Of course, Turtleboy bad. Oh, no, not Baker as in Emily Baker, Broken Baker. Broken Baker did the audio yesterday. I think it was yesterday.
Some people who welcomed the divide in town sat on this very board, and while another who pushed the conspiracy is currently running for a seat on this board, it's truly a shame. This is not what Canton is. Canton has always been a community that has come together in such tough times and stood together through adversity. Instead of rallying, we had members of this community drive a wedge.
I mean, correct me if I'm wrong, but didn't he also use like the Canton PD as his own personal police force? The stuff about the video and the D&E pizzeria and, you know, having other people arrested outside his pizzeria. Was that while he's been the select board, on the select board?
In our town, harass and slander who tried to help. And yes, we had people cheering as the negative attention was cast over this great community. We had former residents who had their own grudge against this town to insert themselves, and others hide behind the words they wanted justice. Well, shame. Shame on you. Shame on those in this community who participated in this behavior. It does nothing to honor the memory of Officer John O'Keefe. I will say this.
Shame on you. Shame. What a shame. What a shame. What a shame. What have you done to honor the memory of John O'Keefe? Yeah, he's literally throwing a temper tantrum, says Law Mama 4. This was hard. The rubber ducky scared me. I think we'll do the audio of the phone calls tomorrow because there's probably going to be some more stuff on Kelsey dropping tomorrow. Tomorrow's Friday. Everything happens on Friday. And I'm pretty exhausted from the first 7 hours I did. And now we're into another 2. So I will do it with you tomorrow. I won't blow you off on that.
Though my 3 years as a member of the Select Board were not what I envisioned, I am proud to have served for those who have supported me and those who have accepted me.
Service.
In the end, you did not break me. Week after week, the behavior of some has been deplorable and just shows you more about who you are than I am.
Brenda Sweeney speaking up at every town meeting. People are deplorable. The deplorables. The deplorables have entered the chat. How did you serve? What did you do? Wow.
The past weekend has reminded me of what our community is really all about. It's about love, support, and what I saw in many members of this community saw through the fiction, saw through the weekly 3 minutes of nonsense, and will stand for defending the truth.
Yeah,
and to my family, once again,
wait,
I'm sorry that you
wait, hold on. We'll stand for defending the truth. Is he plugging their defendingthetruth.org website? Wow, who wrote this for him? He said that's their website, right? Defendingthetruth.org. That's their defense fund. That's kind of funny. Who wrote it for him? He clearly didn't write it because he's reading it off a piece of paper.
And will stand for defending the truth. And to my family, once again, I'm sorry that you had to endure all this pain. I love you all.
Who's clapping? Who's clapping? Hold on, who's there? Well, there's a couple people in the clapping, but I don't know. Do you guys know who's in the gallery? I guess, you know what? I guess that Yuri Buchanan is not allowed to promote the defense fund anymore for defending the truth. His dad and his brother, somebody said nobody cares. Because tell me what you guys think of it. Seems that nobody cares. Thank you, Deshai, for suggesting that. Hey, it's Meg. Thanks for your 10. Says, so whilst he was ghosting her, Justin, and lying to a court, she was taking care of the baby at home, at the park, and at work. And she's the bad parent. Help me understand. Oh, I can't. I stopped trying to figure people out a long time ago. People like him, you'll never figure out. I know that was rhetorical, but I feel you. Thanks for your 10. Lola says, Justin and his mom are giving me Brian and Roberta Laundry vibes. I think there's so much more we don't know, and co-parenting is going to be a nightmare. Sad. Thank you, Karina, who says the best 21 months of my life are learning with you. Thanks, Karina Pinky, for being with me for 21 months. Let's see. We got to have some things to cover for tomorrow. So tell me what your pleasure is. I will get the audio for you on those Justin phone calls. Lauren said she would send it to me another way. So thank you very much, Lauren. You're so appreciated. About 40 of you sent me something about a Boston police officer being arraigned. We can cover that tomorrow. Thank you, Maria, for your Venmo. She says, because it's been a minute. Thanks for all you do. Thank you so much. Thank you, Betsy, for Take Two Venmo. And then there was some, Dr. Russell's Gasp. Thank you so much for your 10 by Cash App. I appreciate you so much. Nancy, for your very generous 50, says, thanks, good to watch Afroman this week. You do such a great job. Thank you so much. Mama Shea, thank you so much for your very generous 75 via Cash App. Says, thanks for covering XO Lemon Proud Cupcake. We can make lemon cupcakes. There is a lemon colored cupcake for, I forget how many months of membership. And there were some coffees in here too. KPT, thanks for buying 3 matcha lattes. She says, you and all you do to bring coverage and commentary always. I'm going to need a lot of matcha latte today. I'll tell you that much. Gigi also sent 5 matcha lattes and says, thanks for the humor. I needed that today. That was the earlier Afroman coverage. If you didn't watch it, please do. And if you did watch it, let me know if you liked it. And I think that is everyone that I need to thank. I'm exhausted. I don't know what time I'm going to go live tomorrow, but what you're going to want to do is make sure that you have your notifications set. Because out of the 130,000 of you, only I think 20% of you have notifications enabled. And only out of that 20%, only like 12% of you have all notifications. And YouTube is changing all of their YouTube is changing their algorithm constantly, and they're trying to push more shorts on you. And so the long form content might not come up in your feed. And so you might want it in your feed. And so you have to tweak your feed a little bit and see what you can do. All right. I'm exhausted. I'm going to go rest. I will see you tomorrow. I'm just not sure what time. Audience clapped because he's finished reading and he's out of there, said Strong Mike. Thanks for you 5. You guys know what to do. Thank you, moderators, for doing this tonight today for so very long. I appreciate you so much. I could never do this without you. And I love you so much. And for all of you who chose to spend so much of your day with me, I love you with all my heart. If I don't see you soon, I'm going to die. Thank you, Gail, for becoming a member. Thank you, moderators. Tip your servers. Do the things. Be nice to each other. I'm going to see you real soon, like tomorrow. Stay cool, stay kind, stay classy, and above all, stay safe. There's some really, really crazy people on the internet. Peace, you guys. Good night. Bench trial for Kelsey starting Monday, gavel to gavel, right here, starting at 9 a.m. Full days, should be over by Friday. And we've been here since the beginning, and we're going to be here until the end. Good night, everybody. Today's the last day of Mercury retrograde. Didn't you promise me that? Thanks, guys. Bye.